Welcome to Washington Square News. This is Op-Ed Live. I'm joined today by Nina Golshan and Lena Rawley to talk about the recent Hobby Lobby case. Thank you for joining me.
Thanks for having us.
So, last Tuesday, the Supreme Court heard two cases tackling the Affordable Care Act, the issues of religious freedom, and a woman's access to contraception. The case that has garnered the most attention has been the Hobby Lobby one. Hobby Lobby, you both know, is a craft store with over 600 locations and over 13,000 employees, and the company has refused to offer care to or access to emergency contraceptive, think Plan B, and IUDs to its employees. So, what do you think? What do you think, Lena?
Well, I just think that it's wrong for an employer to impose their beliefs on their employees. I mean, this is a for-profit organization. This is not a church. So just because they believe a certain thing doesn't mean their employees necessarily have to believe that as well. And it's unfair for them to then push those beliefs on them.
What do you think, Nina?
I think that one of the questions that the justices are going to have to address in the case is what determines a corporation's religious beliefs. Are they just going to consider the beliefs of the Green family that owns Hobby Lobby, or if they're looking at the corporation as a whole, are they paying attention to the over 13,000 employees that make up the corporation? I'm sure that all of those employees aren't Southern Baptists like the Green family.
Yeah, sure.
So you're going to have to consider those employees' religious beliefs as well. So it's an interesting case, definitely.
Do you think the Green family and Hobby Lobby is discriminating against women, against its female employees?
I definitely think that when you want to withhold care that is exclusive to women, I think it's just discriminatory, and they're hiding behind a claim of religious liberty, which we saw happen in Arizona.
Yeah. Religious liberty it's not a claim with any grounds, because if we look back at what happened in Arizona, businesses were trying to get a law passed where businesses could reject a consumer based on their sexuality,
which was vetoed.
It was vetoed, but they were trying to get it passed, and basically an employer, a business could say to a gay man, well, we don't want to serve you because you're gay, and they could chalk it up to their religious beliefs and as an excuse. And that's not fair, because then that creates a whole new era of segregation based on sexuality and based on gender.
Yeah, the distinction between sexuality and gender really doesn't matter. It's the same, still discrimination.
Right, and the Constitution doesn't exactly guarantee religious liberty when it's used to discriminate against a certain group and reduce their civil rights.
Yeah, because in that case it's not freedom if it's infringing on someone else's freedom.
Yeah. So, which way do you think this is going to go? The way of Sebelius or Hobby Lobby?
I think that they're going to rule in favor of Hobby Lobby. Based on past rulings, the Roberts Court has ruled in favor of businesses.
It's a very conservative court.
It's a very conservative court. Past examples of that include the Citizens United case, where they ruled that corporations could spend freely in elections. They also didn't want to take on the case involving the Comcast merger that happened recently.
Mm-hmm.
So I think there's history there for supporting business over employee rights and basic class action lawsuits, human rights lawsuits, things like that.
Lena?
Yeah, I definitely agree with Nina. I mean, as unfortunate as it is that they would, agree with Hobby Lobby, I think that she definitely has a good point. But also it's the fact that it's a male-dominated Supreme Court.
Yeah, 6-3.
6-3, yes. So the fact is women don't have as much say as they should, and in this case the men really can't be completely empathetic to the situation, because their rights aren't at stake. It's not like they're being I mean, if they were being if a company was saying, okay, well, men can't buy condoms, then that would be infringing on a male right to contraception. But in this case, it's
very specific.
Yeah, it's very specific to one gender. So,
and it's interesting in the arguments on Tuesday. It's very clear the divide between the female justices and the male justices. Ginsburg, Sotomayor, and Kagan were much more adamant in trying to define boundaries of religious beliefs versus discrimination of employees.
And it's if you're a man, you really cannot fathom a lot of the time how it would feel to be denied such a basic right, I mean, a man doesn't know what it's like to be put in the position to have to get an abortion, or you know.
And it also points towards just broader problems in the government in general about how a lot of the time it's mostly men deciding on issues having to do with women's rights. So I definitely think it's a women's rights issue.
And the conversation becomes totally different and more interesting, I think, when it's reframed as a women's rights issue and less a religious freedom issue. So what do you think, I mean, whichever way the court decides, you think Hobby Lobby, you as well, what does it mean for the Affordable Care Act?
Well, if the court does rule in favor of Hobby Lobby, then certain female employees working for corporations who refuse to provide contraceptive coverage aren't going to have that coverage, and other employees working for different corporations will, which defeats the purpose
which totally defeats the purpose of the Affordable Care Act, because it's in place to give everyone the equal opportunity for health care. So if some women at another company are going to be able to have access to birth control, but women at Hobby Lobby aren't, then that equality is just out of the picture.
Yeah, we'll have to wait and see what the court decides. Thank you for joining me.
Thank you.
I appreciate it.